So, class action lawsuits, and what are those? I was just thinking about one that was just the Google one. Yeah, I think it's just 3 gals from Google have filed, and they hope to make it a class action lawsuit against Google for gender discrimination. 3, I don't know if there's other gals, if they're hoping. Can 3, I think it's more than one, can be considered a class action lawsuit. And I imagine they're suing, saying that the overall conduct affecting all women, or most all women anyhow, was such that it was discrimination. So that's one that I see now. Again, it's filed on behalf of all with a similar claim, and so that's what those gals from Google would be doing. Notice must be given to all class members. Now, if you are easily findable, they'll send you in the mail in all likelihood, or somehow get a hold of you, phone call, whatever, okay, to be a member of the class. Or if on the other hand it's more general than that, and you see even TV ads, you see ads in newsprint, magazines, you name it, online, I've seen them several times, that if you used this product, one of the ones that's been big lately is baby powder, and women that used it for hygiene purposes and have suffered cancers, I think ovarian, those types of cancers, they're part of a class action lawsuit against Johnson & Johnson. And if they can't, how do you identify and find each woman that has purchased baby powder? Stores don't keep track of that information, and you have to then put in those general ads. That's why you'll see some of them on TV and whatnot, okay, to try to identify the members of the class. Okay, and that's not up for J&J to determine that. That's up to those that want to be plaintiffs in the lawsuit. They have to try to give notice. Okay, the plaintiffs pay the court costs. Now, generally speaking, if the plaintiff wins, those court costs become a part of the award, the settlement benefits class, and it releases all claims. The two, there's a couple that my wife and I were involved in, and kind of long stories. I'll try to give you one that's short story. We got a letter in the mail the one time, and we were part of this class action lawsuit. Apparently some motel, and it said that we had stayed at this particular motel, and we couldn't even remember having stayed there. And they gave the dates, or the approximate dates anyhow, and we had to think back, and sure enough, when we had been traveling and we'd gone through Las Vegas, it was one of those times when we hadn't pre-planned any place to stay or anything, and just pulled into a motel and stayed. Well, it turned out that this motel, and it was a small chain, they had 5 or 6 different motels was all, but it turned out that they charged us, fuel prices were really high at that time, natural gas and everything, so they charged us a $2.50 extra charge for our room. It was a surcharge for that fuel expense, or that energy expense. Well, we didn't even remember any part of that, but sure enough they had, and so I think I did it just as much for fun as anything, and we participated. Well, it all got settled. The lawyers got paid, I think, over $7 million, and we got a coupon worth $2.50. If we stayed at one of those motels, it was for a discount. If we stayed at one of those motels, anytime in the next 2 years, I think it was. Well, there was a little chance we were going to stay at any of those motels, and $2.50 wouldn't have been a deciding factor. So it was kind of I would call it kind of a farce, but the lawyers made out pretty well. The other one we were involved in, literally, honest to God, I can't believe I didn't keep this. I think I cashed it just to be almost kind of spiteful, but in the end, my wife and I literally actually got a check for 25 cents, and I think that was what each of the members got. And I think in that case, the lawyers maybe got $40 million or something. I don't remember exactly, but moving on. So procedural rules. Remember, we have substantive law and then procedural law, and so the procedural rules here. We have the pleadings, and the pleadings are the plaintiff or the complaint and the answer. Pretrial motions, and there's always a number of pretrial motions. Usually, the defense is going to say a motion to dismiss, the plaintiff's case isn't prima facie, and different motions like that. A motion for also after the complaint and the answer, or motions for a summary judgment, and other motions like that can happen. So those happen. Judge rules on them. If you move forward, then you go through the discovery process. And I was involved, several times, I would say, in the discovery process, where you have to give depositions, affidavits, those types of things. Okay, are all a part of that. Interrogatories. I think that might have been part of your homework as well, was the types of things that can be required in a discovery process. Then you might have a pretrial conference, and the judge might take that opportunity to look and say, things don't look good for this side or that side. You guys might want to consider a settlement. Okay, if that doesn't happen at any time in here, settlement can take place. And so, if that doesn't happen, then you go on to the trial. Then there's post-trial motions. Right, and they can include a motion for a directed verdict, motion for a judgment notwithstanding, jury's decision, and ultimately an appeal. Okay. So pretrial, again, you have the pleadings, which is just the complaint and the answer. And so if it's a public and criminal, the complaint, is filed by your local, maybe county attorney. Okay, if it's a federal offense, murder, capital case type of a thing, you might have a grand jury. Okay, and the complaint, the complaint before the grand jury would still come from a district attorney or a federal attorney, appointed to prosecute these things. Then you'd have answers and you'd have counterclaims. A default judgment, and we as a bank and most banks, credit unions, they earn a lot of default judgments. And what's that mean? Well, they take their case to a court, be it a small claims court or district court in some cases. And generally speaking, if we were suing somebody because they hadn't paid us back, generally speaking, they just wouldn't show up, and we'd get a judgment by default. In all my years at banking, when we filed those, I think I only had one defendant that ever actually showed up, and literally it went like this. The judge said to the defendant, well, did you sign this loan document? And the defendant said, well, yeah. And the judge said, and are you disputing the amount that the bank shows here as being owed? And the defendant said, well, no, I don't dispute the amount. And I think the judge asked if they had something to say, and the person said no. So we got our judgment in that case. It just wasn't by default, but it was a judgment, still granted to us by the judge. And there's little that they could dispute, and that's why we would oftentimes get those types of things. So again, you got the plaintiff files a complaint, defendant motion to dismiss. I said that's generally going to happen from the defendant. Why wouldn't you? It's one of those things. It's even if it's a long shot, you still just fire ahead and see if you can get the judge to dismiss it. Again, for any court to exercise authority in any given case, which of the following must happen? Jurisdiction over the subject matter, personal jurisdiction and standing. You remember that from the beginning, so it's got to be all of the above, right? Yeah, let's talk a little bit about the discovery process, right? Purpose is to, unfortunately, when you watch Perry Mason or Matlock or any of those good law shows on TV, the courtroom drama usually doesn't happen, and the reason for that is discovery. So a lot of the stuff is ferreted out, and the reason for that is why put a jury through those types of deliberations and whatnot. Why do that? Let's ferret out the evidence ahead of time. It might lead to settlement, which is good. The courts favor settlements and whatnot if they're appropriate. And just it brings the issues to the forefront and gets them discussed, and then there's not surprises when it comes to the trial. Then both sides are presenting their case, that the judges determine what's admissible and what's not, and the jury gets to decide. So it assists, right? It narrows the issues, et cetera, et cetera. The methods, kind of talked about that. Interrogatories, requests for production, depositions, requests for admissions, affidavits. We had those. So this shows you discoverable information. So that's those types of things that often get looked at or asked. And then evidence admissible at trial. I know a few times when I had to be deposed, deposition or be deposed, they'd ask questions sometimes that were just out in left field, and our attorney would say, well, you can go ahead and answer that. It probably won't be admissible in court. Okay, so you'd answer it knowing sometimes that it wasn't a court thing, just kind of for the heck of it. So discovery's costly. It takes a long time. Okay. Searching for information, doing the depositions, copying, shipping, et cetera, et cetera. I think one time I was deposed. It was very lengthy, and the little court reporter person, they got their little fancy machine that you see those folks in the court have, and they're taking that all down. They have to convert that to text. That's kind of a shorthand thing, and it gets converted to text, which takes them a decent amount of time. And then they would bring it in, and I had to read it, okay, and it was a small book, and I had to read that and verify then that it was an actual rendition of what we had said or what had transpired during the deposition. So it was lengthy, it was thick, and it was, I can't imagine what the whole court reporter person had to go through. So things that can be abused, right? Parties can become aggressive, and I was never in one where the parties became aggressive. Damage to the litigation process. So you do take some of the surprises out of it. You bring other elements in maybe that aren't appropriate. Just things like that. Okay. So the key is to act reasonably and prudently. You're trying to get justice done. Okay, and avoid extreme positions. In the depositions, and like I said, that there was times when I answered questions that seemed maybe inappropriate, but there were also times when a question was asked that was clearly inappropriate or clearly not related to, or maybe it was an extreme position, and our lawyer then would say, hey, you don't have to answer that. Okay? And, you didn't have to take the fifth, you didn't have to do anything. If your lawyer advised you against answering it, you just didn't answer it. Okay? And so that's not just in depositions, but that would be the other things, the interrogatories and those types of things as well. Yeah, let's stop there for a bit, and then we'll come back and talk about motions.